do.
Good morning. By the way, who's supposed to start with the cross-examination?
Chairperson, that was for yesterday. I had a commitment in Johannesburg at 5 o'clock, but I've discussed the matter with my learned colleagues. I think we can revert to the original arrangement. And may I take this opportunity, also, Chairperson, to apologize for being later. I was just caught up in very, very heavy Gauteng traffic.
I'm ready to proceed if you're ready, Mr. Chairman. Dr. Young, I'm acting on behalf of Advocate Fana Shlongwane, so my questions will relate to his position and your testimony relating to his position only. I would urge on you to please listen to the questions that we can attempt to finish my cross-examination at least in 20 to 30 minutes. If there's anything that you don't understand in a question, please do not hesitate to ask me and I'll gladly clear it up. Now, Dr. Young, I would like to at least attempt to get some perspective to your testimony relating to my client and to give some structure to your testimony. So what I would prefer to start with is that we have a brief look at the sources of your information relating to my client. I think the best way to start this off is to look at your own statement in this regard, and I refer to paragraphs 11 to 13, where you dealt with the position of participants or advisors, which would include my client. In paragraph 11, you said, although my statement contains averments and allegations applying to all of the elements of the SDPs, I have personal knowledge and specific knowledge of one component of the SDPs in particular, namely the acquisition of 4 patrol corvettes for the SA Navy due to CCI systems and my own involvement therewith. In paragraph 12, you said, however, since my initial involvement, it has become the nature of things to become as familiar and acknowledgeable with the other aspects of the SDP, such as circumstances allow. In this regard, I have come into contact with many people interested in the SDPs, including official South African and official international investigators, media investigators and writers, book authors and whistleblowers. 13, you said regarding these whistleblowers, many of them prefer not to come forward publicly and because of my already public profile have approached me to hand over information and evidence to the authorities on a confidential basis. Would that be a description of your knowledge and where you obtained your knowledge relating to at least my client?
Yes.
In your evidence, you in fact referred to yourself at some stage as a kind of a conduit, was the word that you used. Would that be a correct description of your position?
Yes, in certain circumstances, yes.
Well, if you say in certain circumstances, what are the other circumstances?
Well, some of them, Some of them are of my direct intention. Some of them are where people have specifically asked me to deal with a certain matter, and some is on an anonymous basis.
What do you mean by your specific intention?
Well, this is almost exclusively regarding the Corvette Combat Suite.
No, but you recall that I said I'm only concentrating on Mr. Shlongwane, and clearly you don't try to suggest that he was involved in the Corvette acquisition as well.
Yes, and I don't want to get argumentative, but I understood this as to be as a general introduction. So anyway, if you now clarify it with regard to these three paragraphs, then it's only with respect to as being a conduit for information.
You also described yourself yesterday during cross-examination of Mr. Cooper as just a messenger bringing the info that came to my attention. That would be a proper description if I understand you properly.
In this context, but it's not just handing over a bunch of documents. It's doing it in the context of this commission providing oral evidence as to the context and allowing myself to be cross-examined. So it's not just as simple as handing over. It's in this particular forum.
Well, if we can summarize it, it's clear on your own version that you have no personal knowledge relating to any of the issues with reference to my client. With reference to my client, you only, in your testimony, acted as a conduit.
What I do have personal knowledge of is his witness statement and his oral evidence, and the evidence that he had used, and I think I have a personal knowledge of that.
Maybe you don't understand my question, Dr. Young. His statement and his evidence is before the commission. I'm now concentrating on what you brought to the commission relating to my client. In that sense, you are only a conduit. Would you agree with me?
In that specific sense, yes.
Now, Dr. Young, now that we've cleared that up, I think let's move then on to what you in fact did say relating to my client. And again, I think the main source of what you in fact testified and or stated relating to my client, we should go to the main source being your statement. Would you agree with me?
Well, my statement very, very briefly addresses that. That's not the main source. That's just an introductory to the source of documents.
Well, you prepared an extremely lengthy statement, not so?
Yes, but very, very little in regard with your client.
Why? Because you didn't know much about my client.
No, there are a couple of reasons. One is that this evidence I'm giving is only in response to, well, say two things, but mainly your client giving evidence, I think, on the 11th of December. And I had no intention of traversing that before then. And of course, I was also expecting other witnesses to traverse the BAE leg and not leave it to me. It certainly has been dealt with in passing, but not very extensively. So by December, January, February, especially after reading the transcripts of the evidence on the 11th of December, I felt it incumbent upon me to at least bring to the attention of the Commission what I did know.
What is the purpose of you testifying here, Dr. Young, relating now in general, not only to my client? Would I be correct if I understand it, that you came here in order to attempt to assist the Commission with reference to the questions asked from them in the terms of reference?
That's correct, yes.
So, what you attempted in your statement and subsequent evidence was to assist the Commission in, for instance, what I regard as maybe a very important issue in the terms of reference, and that is whether any person within and or outside the government of South Africa improperly influenced the award or conclusion of any of the contracts awarded in the SDPP procurement process.
That's certainly one of them, and probably the most important one regarding your client.
So, would I be correct if I would accept that you would have provided all the information that you had relating to my client in order to assist the Commission?
I provided as much as I could that was relevant within the very short timescales and resources that were available to me.
Yes, well, so then let's look at what you have in fact provided now that we've cleared up what your intentions were. I've gone through your statement and dissected it, and it appears to me, and you must please correct me if I'm wrong, the first reference that I could find relating to my client was paragraph 517 of your statement, and all that dealt with was to state that the reference to young friend is in fact a reference to Fana Shlongwane. That's the first reference that I could find.
That's correct.
Sorry, Mr. Chair, would you like the opportunity to get the statement before I proceed? Do you have it? The second reference that I could find was in paragraph 664 in 3 of the sub-paragraphs. Am I correct?
I can't go to paragraphs as quickly as that unless if you give me a page number possibly.
Let me see whether page 171.
Yes, this regarding a response to General Meiring's memorandum, is that correct?
Correct. But what I'm putting to you, as far as what I could find, this paragraph was the second time that you dealt in your lengthy statement with my client.
Yes.
The first reference we find in paragraph 664 sub 5, where you said the following: Meiring complains about the difficulty of obtaining evidence after years have passed, while admitting the existence of about 4.7 million pages of documents secured in 2008 raid on BAE, Fana Shlongwane and others. But this positive aspect it turns into another negative on the basis that it could require further effort to peruse and analyze. That's what you've stated in 664 sub 5, am I correct?
That's correct, yes.
Then in 664 sub 7, you again refer to my client, stating that Meiring claims that the 3 suspects in the BAE leg have all passed away. Modise, Defence Minister during the period of arms procurement, and Richard Charter, one of BAE's local agents, have indeed both died. But the identity of the third dead suspect is a mystery. Certainly, Shlongwane, who was regarded as a suspect because he could have influenced the deal as Modisi's official defense advisor and subsequently received more than 240 million in payments from BAE and its partners, is alive and well. That's the third reference then to my client.
Yes, that's correct.
And the last, or the next one is 664.8. Myron claims there is no prima facie evidence against any person in the BAE matter, even though a South African judge confirmed an offshore freeze on Shlongwane's funds as the proceeds of crime. Although he has denied wrongdoing, Shlongwane has not denied receiving payments from BAE.
Yes, that's what my statement says.
Those are the only references to my client in your initial statement. Then subsequently on the statement that we received on Sunday, I think you provided already during the course of last week, we have paragraphs 809 and 810, where you attached certain transcripts for the Commission's attention. Am I correct?
That's correct, yes.
Now, if we can just take a minute on 664 sub 8, where you referred to the fact that a South African judge confirmed an offshore freeze on Shlongwane's funds as the proceeds of crime. I want to ask you a couple of questions. Do you know the legal principles relating to a restraint order?
No, I can't say I do.
So you don't know what the evidential requirements are for a restraint order in terms of what we refer to as POCA, the Act 121 of 1998. You don't know what the requirements are.
Well, just what is POCA?
It's the act in terms of which restraint orders are made that you're referring to in 664 sub 8. It's the Prevention of Organised Crime Act.
Okay, I'm not intimately familiar with it. I'm just familiar that such an act exists.
Are you aware of the fact that in order to obtain such an interim order, the prosecution or the Director of Public Prosecutions approach a judge on an ex parte basis in chambers?
I'll accept your word for it.
You have not known that previously?
Well, I do know that one can approach a judge in chambers on ex parte basis, but I didn't know whether that's an exclusive mechanism or their open court mechanisms. I don't know what all the mechanisms are, but if you say that is a relevant one, I'll accept that.
Well, the fact is, if we can summarize it, Dr. Young, and I don't mean it in a derogatory manner, you have no clue of the legal principles relating to restraint orders.
Well, I think saying no clue would be putting it a bit strongly, a bit highly, because I do have a clue. I'm certainly not an advocate or a lawyer, and I don't have working experience of this, but I do have some clue.
Well, your clue is that a procedure of that nature exists. It seems to me that's the sum total of your clue.
Well, it's not quite the sum total of it. As far as I know, is that not only that the procedure exists, but a procedure in this particular context was actually used.
Yes, but we're talking legal principles.
Well, they're very closely related.
Would I be correct if I say that you didn't have any clue of the factual allegations contained in the application that was brought before the judge that you referred to?
No, I certainly had some idea. I wouldn't say I had no clue or no knowledge whatsoever. I mean, I've been following this this matter for quite a considerable period of time, and I'm certainly had, and as far as I know, it related very directly to even to Principal Investigator Gary Murphy's affidavit from 2008. I know that I've read affidavits from, I think, Billy Downer and a colleague of his in the Asset Forfeiture Unit, Carla Sala. So I certainly have some background. It's not that I had no clue whatsoever.
You clearly haven't studied the application.
I don't know what basis you can say that I clearly haven't studied. I haven't studied it as hard as I'm writing for an exam tomorrow, or even that I knew that I would be cross-examined to this depth on this particular matter. But I'm not saying that I've studied it. I certainly have read it for whatever is available. So if you mean studying it from the rigorous, I would say no, but I have reviewed it, if on the less onerous meaning of the word study.
And do you know what transpired in that application, what the outcome was?
From what I can remember, I'm now really working from memory, because whatever I'm saying is actually more in the context of the Directorate for Priority Crime Investigation Unit's abandonment of the investigations. It wasn't specifically regarding this issue or your client. But what I can remember, and going back a considerable period of time now, is that an application was granted, but later your client, I think represented by yourself and your attorneys here, made a representation to the National Director of Public Prosecutions, and I think that application was withdrawn or abandoned, but that's what I can remember.
Well, let me put to you what the correct position was, Dr. Young. The application, the interim order was indeed obtained on an ex parte basis. I can put to you. Do you want to comment on that?
Well, it's certainly a good foundation for at least some of what of my position is.
Well, I don't understand your answer, but let's proceed.
Well, the point I want to make is it wasn't based on nothing whatsoever.
The question was, or what I put to you, Dr. Young, it was obtained on an ex parte basis. That was the only question that I've asked, or what I've put to you. You certainly do not dispute that.
No.
Do you know what ex parte basis means in legal terms?
I think it means like a unilateral approach, but one party to the judge without a bilateral opportunity for the other party to state their case. That's my layperson's understanding of that is.
Well, that's a good understanding, Dr. Young. It's you approach court without giving the other party the opportunity to put his case.
Yes.
And therefore only an interim order is granted, and then it's postponed to a future date in order to present the other party with the opportunity to answer to allegations. Do you understand that?
Yes, I can accept that.
And once that opportunity had been provided to my client, and the National Director of Public Prosecutions had been approached and the answers given, they abandoned the order and, in fact, withdrew the application. That was the factual outcome of this application.
Okay, I think I'm correct in saying, or repeating what I said before. It was done on a representation basis and not on in a kind of an open court bilateral basis.
Now, if that is the position, what assistance do you get from the fact that a South African judge on an ex parte basis granted an interim order which was abandoned when the other side heard the version of my client. What weight can this commission attach on your assumption or on your view to the fact that an interim order was in fact granted?
It's only by way of introduction of the relevance of the later evidence, and I think what is relevant in my statement here is saying Hlongwane has not denied receiving payments from BAE, and it's really on that. That was the contextual introduction. In all of those processes, ex parte or representations, I don't think that was denied. So I think it is relevant to say that the rest, what I wanted to provide, not so by way of my own evidence, but as giving material to the Commission, is the true, or at least another view of the circumstances regarding the receipt of these payments from BAE.
No, but you will certainly agree with me, Dr. Young, now that we have the full picture of the objective facts, that the fact that a judge granted an interim order under those circumstances doesn't give any weight to any allegation or theory that my client received any money in an unlawful manner.
I think that might be true, certainly in a court of law where there's a burden of proof. But I think, at least as an observation, and hopefully a relevant one and a sane one, is that very few judges that I have ever come to know, I don't know any personally, but grant interim orders or any other orders, even on ex parte basis, based on the affidavits of practicing counsel, senior counsel in the case of Advocate Downer, that can be based on complete nonsense. There has to be at least some plausibility in those affidavits submitted in that ex parte application. The fact that they get that the actual application gets denied at a later stage, I don't think, in my intuitive view at least, or layperson's view, that means that the contents of those affidavits that founded that application also become completely irrelevant or untrue or of no sound basis whatsoever. I think that's the point that I would like to make.
No, but it seems to me that in principle you agree with me that now that we have the full picture based on the objective facts, you agree with me that there should be no weight attached to the fact that a judge granted an interim order on an ex parte basis as proof or any weight to any allegation that my client received any unlawful payment.
No, I think there were quite a few sub-themes in that question, and my answer is I think no to all of them. First of all, I'm not stating here. I don't think it's my evidence, written evidence, that your client received unlawful payments. That's not for me. Also, I have no burden of proof here. You used the word prove. Then, I'm not trying to prove anything. All I'm trying to say is that there is relevant information that is both relevant in its own context. It's relevant to the Commission, but it is even more relevant to the point that I bring up, the points that I bring up, and the documents that I bring up at the end of my statement.
Let's move on, Dr. Young. It appears to me, also on the basis of what you've just testified, that the high water mark of what you stated in your statement and in your evidence is that we find in 664 sub 7 in the words, Shlongwane was regarded as a suspect because he could have influenced the deal as Boudisi's official defense advisor. That's the high water mark of allegations against my client if I have regard to your statement.
No, that's also not true. Certainly this was the introduction part. The subsequent part is that my understanding of your client's testimony, both written and oral, is that he never received any payments whatsoever from BAE until 2003. That is the firm basis for me continuing that theme in the what I call my extended witness statement.
Please refer the Commission to where my client said he only received or entered into an agreement only in 2003, Dr. Young. We have already actually went through this and you withdrew this allegation previously. You'll recall what happened on Monday.
No, I don't remember withdrawing that.
You have a very short memory, Dr. Young.
I don't think so at all. I just cannot. I don't think it happened. Remember things that didn't happen. I can't remember me making that statement.
Can you recall that I at one stage objected to your evidence and that I invited you to refer the Commission to the statement and or evidence of my client where he stated that he only entered into an agreement with BAE in 2003 and that you then actually apologized? Can't you recall that?
No, I don't.
Well, I'm not going to take you there. The record will speak for itself, Dr. Young. If you say what I stated to you, what I could find in your statement as the high water mark of your allegations against my client, can you please refer me to any portion of your statement contradicting what I've said to you?
I'm not relying on my statement, except the reference in my statement to both your client's written witness statement and the transcript of his oral evidence.
Dr. Young, please listen again to my question. What I could find from your statement as high water mark of allegations against my client was what I could find in paragraph 664 sub 7, which I've read to you. If you do not agree with me, and I'm referring now to your statement, please refer me to a paragraph or paragraphs in your statement contradicting what I've said.
I'm referring to my witness statement at paragraph 809.
Well, let's read 809.
It says, I think I've only got two paragraphs regarding this theme in what I call my extended witness statement. And the 809 reads, the essence of my evidence is that Hlongwane did not only conclude certain consultancy agreements with BAE during 2003, he did so prior to that as early as 1998 and received substantial payments via BAE Systems, Red Diamond Trading Limited, and even more indirect routes.
Let me ask you the question then again. I'll put it to you. What I could find as an allegation against my client with reference to the terms of reference, more in particular, paragraph 1.5, and I don't want to read it again unless you want me to. The high water mark of allegation against my client is to be found in paragraph 664 sub 7. And if you disagree, please refer me to a paragraph.
No, my evidence is not direct in terms of my own witness statement. It is only with reference to the documents which I've adduced, which, in my own view, go the way to prove two things, and that is that your client received payments indirectly from BAE long before 2003, and also the BAE representatives are on the record under oath in terms of these documents that I've adduced, is they were meeting in the early stages of the selection process. Certainly in the 1998 period, maybe even 97 period, is they were introduced to Advocate Hlongwane, and I think, and who was introduced to them unashamedly or as BAE's consultant.
Dr. Young, I'm interested in the terms of reference, and I want to restrict my cross-examination to what is relevant. I don't want to develop theories or suspicions, etc. So I want to concentrate on the terms of reference. We have already cleared that up. As far as my client is concerned, we should look at paragraph 1.5 of the terms of reference, the one that reads whether any person or persons within and or outside the government of South Africa improperly influenced the award or conclusion of contracts. You understand that?
Yes.
Now, what I'm putting to you in your statement, I couldn't find any allegation that my client, in fact, improperly influenced the award or conclusion of any of the contracts awarded in this program. Am I correct or am I wrong?
You're wrong.
Please show me in your statement and read the paragraph to us.
No, it's not in my. I didn't say it was in my statement. It's in my evidence.
I'm asking you for the 10th time. We are dealing with your statement now.
Yes, my statement refers to the evidence documents. It is contained within the evidence documents. I haven't seen the transcript, but I went through that in some detail in my evidence in chief. And I've just explained it now. Again, this is my oral evidence. My oral evidence supersedes. My witness statement is only a summary of what I was going to address in oral evidence. And I think I did it adequately at the time. But what I've stated in terms of the terms of reference, if it is true, what is contained in the documents which I have adduced into evidence, I know that everybody's been copied with every single page of those, I think, 19 or 20 documents. It's what's contained within the documents. As we know, I'm not allowed to, and I'm certainly in this case I wouldn't have, tried to traverse all 2,000 pages or whatever it is. But what I stated then, and I'll state now, is that there is the clear evidence, oral evidence at least under oath, transcripted into transcripts of those interviews under oath of the relevant BAE people, where they talk about meeting Advocate Hlongwane before 1999, January 1999, when he ceased to become the minister's, or at least officially ceased to become the minister's ministerial advisor, and was communicating and giving advice to BAE, and to all intents and purposes, it would seem, at least on the face of it, he was doing that while still working working as the minister's advisor. And if that is true, and this is not my evidence, it's just the evidence that I'm bringing to the Commission. It's the BAE person's evidence. If it is true, now we are allowed to make those kind of presumptions for the purposes of giving. If it is true, then the clear logic is that Advocate Hlongwane was working for the minister as a defence advisor, and at the same time giving advice to a competitor. And that would fall directly into the terms of reference, paragraph 1.5, in my own understanding and view.
You will agree with me that in your statement, Dr. Young, there's no allegation that my client improperly influenced the process. And I'm referring to the statement. Please don't favor me with a 5-minute answer again. I'm only referring to your statement. We'll deal with it step by step.
Okay, in the statement there isn't directly no.
What you say is that the Commission should have regard to the couple of thousand pages that you have presented to them, and they should then from that make the inference that there may have been improper influence.
Well, not purely, barely on their own review of the documents, but based on the introduction to it, which I gave in evidence in chief, which was it was not insubstantial, but it basically contained all the gist of what was important and contained in those adduced documents.
You were invited on a number of occasions to refer to specific portions of that evidence which you chose not to refer the Commission to. Am I correct?
It was that is true, but it was only because it was getting to late on Monday morning, and right at the beginning the chairman had said that I'd undertaken to only be an hour or maximum of 2 hours. And as it was, it was getting towards, in fact, I was given until lunchtime. Lunchtime ended at 1:30 that day, and the only way that I could meet that undertaking of completing by that time was to, as I said, working from memory and indicating which of those witness statements and evidence documents was relevant in each instance. But giving a oral summary from memory of what my evidence was that would be borne out by those adduced documents.
The fact is, Dr. Young, as we sit here, we still do not know on which portions you're relying for this allegation.
No, not specifically. But what I can vouch for is that all of those documents are relevant. I need to be frank in saying, of course, I am in possession of. I mean, that is just a tiny fraction of what was provided to me regarding the BAE section, but regarding your clients and your client's evidence on the 11th of December, I extracted I think it was 9 transcripts of interviews with BAE. It was actually 8 transcripts with BAE employees or former employees, and just 1 with a former BAE advisor, Alex Roberts. So there was only 9 altogether, and then there were about the same again of documents backing up what was contained in those transcripts. So, all of those documents are relevant. It wasn't practical, considering the directive, the ruling from the chair, to spend hours, it would have taken hours. To go through all of those documents and find the relevant paragraphs. So I did that from memory, and it was, as far as I'm concerned, it was cogent enough. And I can't remember thinking back about it and saying, well, I left anything important out or made any mistakes. So certainly the record of my oral evidence, I would believe, in my own view, for my own purposes, and this is my evidence, for my own purpose, my own evidence, it does suffice.
Dr. Young, I took some hours spinning on those documents that you handed in, and I can put it to you that I couldn't find a single allegation in the bundles that you provided stating or alleging that my client improperly influenced the award of or conclusion of contracts. Not a single one.
No, that's my own conclusion from the clear. You know, one doesn't only make conclusions from conclusions. One makes conclusions from premises. That's the way logic works. Valid or cogent conclusions in natural logic come from premises, not conclusions.
I'm not interested in your theories, Dr. Young. What I'm interested in is the objective facts. Must I take it that you agree with my statement to you that there's not a single allegation in those 5 bundles running into thousands of pages alleging that my client improperly influenced the award or conclusion of any of the agreements that he was involved in?
You talk about facts. Thank you for that. The facts contained in those documents are the premises for the logical conclusion. In two regards that are in this context. One is what your client's testimony was about regarding only entering into contracts with BAE and getting payments from BAE in 2000 would be incorrect, well, at least seemingly on the evidence of those involved, including people who made the payments, including the companies. I mentioned all of them, well, from BAE headquarters, marketing services, to Red Diamond Trading Limited, to Arsto, to West Unity and CRC. All of those are facts. In terms of logical argument, those facts become premises, which eminently support the contention I'm making that it wasn't true that your client only received payments directly from BAE emanating from contracts signed in this later time frame and directly from BAE. There's adequate evidence to show that he received several millions of pounds from at least from the 99 to 2001 period. That's the one part. The other part is, I've said, on the statements or answers to questions under oath from the Serious Fraud Office. BAE employees have alluded to them being in contact with Mr. Hlongwane in the 98-99 period, or 97, 98, 99 period. I'm not 100% sure of the exact extent of it, but certainly the 98 period, when he was clearly working as the advisor for the Minister of Defence. But at the same time, they considered him as their own advisor, and certainly in even more instances as their source of information. And in my view, that is adequate source facts, premises for my own conclusion is that would be a relevant or valid, a cogent conclusion would be that would be involved in the irregular awarding of the contracts.
I'm sorry, can you just put the question I came for the last time? Let's see if we can get an answer.
Yes, I in fact wanted to ask him which question he answered, because it's definitely not the one that I asked. Dr. Young, you have a way of just talking if you don't know what to say. Please listen to the questions, then we can finish the cross-examination. I said to you, I took the hours that you said you didn't want to take. I went through these statements and I couldn't find a single allegation in any of these statements that you presented the Commission with alleging that my client improperly influenced the process of awarding contracts. If you disagree with what I say, please refer us to the portion of any statement that you rely on?
Well, if I can't disagree with you. If you couldn't find any, then that's your version, and I'll have to accept that.
Thank you. It's not my version, it's the objective facts, Dr. Young, but what I could find was very interesting. You've inter alia provided the Commission with a, let's put it in inverted commas, a statement of a Mr. Irving. Am I correct?
Now, Irving, that's correct.
Now, going through his statement, if indeed you can call it a statement, but what you presented the Commission with, it appears that Mr. Irving was only involved in the process in the initial period. Do you agree with that?
No, I wouldn't have said it was. From my memory, is that he actually took over certain of the duties from Alan MacDonald. Specifically, I can remember Sir Kevin Smith replaced Alan MacDonald as the regional managing director, and that he asked Niall Irving to approach all the covert agents with a view to reducing these commissions. So that would indicate to me that he wasn't only involved only in the beginning. In fact, it would be more not necessarily at the very end, but certainly later than the beginning.
Well, I'm referring to his own evidence. He said in 2000 there was something wrong with his visa to enter South Africa, but he was only involved till about the beginning of 2001. That is what he says in that statement that you presented the Commission with.
See, now you're confusing me, because he says he was only involved until 2001. That's the latter period. But 2001 is well after the contracts were signed. So I'm not quite sure what you're getting at or what you're asking me here.
Well, it doesn't matter. What I want to put to you is a portion from his evidence, Dr. Young, just for what it is worth, on page 3737 of the file 9 that you presented to the Commission. And I can read it. It's short. We can maybe save time if you want to check whether I do it properly and fully. You can do so. What he says, top of page 3737.
Sorry, could you just refer me to the actual page of the interview? It's at the bottom in the middle.
The actual page at the foot of the page is 1818. But the paginated pages is 3737. Do you have it in front of you?
I've got the correct page as far as I know.
Let me read to you the relevant portion. And there were also people like Shlangwane whose motive, in my opinion, were driven definitely by their beliefs that the ANC government had to succeed and things had to be right. They were motivated on that grounds, not on the ground of financial benefit. And that I firmly believe. Have I quoted correct?
I didn't see it, but I can remember that.
That certainly doesn't suggest any unlawful influence into contracts, if I understand that portion, Dr. Young.
No, I would disagree.
Well, I'm not going to land in the trap and ask you why, because I think we've heard enough illogical answers from you, Dr. Young.
No, because it's not the ANC. It was, clearly just on your own version, it is that he was acting on behalf of the ANC. It's not the ANC who drives military acquisition. It's arms corps.
Just hold on, Wesley. Can you read that paragraph again? And let's get Dr. Young to comment, if he can.
Certainly, Mr. Chairman, because it actually refers specifically to my client by name. It says, and there were also people like Shlongwane, whose motive, in my opinion, were driven initially by their beliefs that the ANC government had to succeed and things had to be right. They were motivated on that grounds, not on the grounds of financial benefit, and that I firmly believe. Do you want to reconsider your nonsensical answer, Dr. Young?
Only that it is relevant. It's not even the ANC government. Sure, I would agree that it's the correct thing to do things right, but it's not the ANC government who is responsible for acquisition. It's arms corps.
Just hold on, Dr. Young. Are you saying that statement, the one that Advocate Sidley is reading, is he reading it properly? Or are you saying that even if this what is contained in that statement, you don't agree with the sentiments expressed there?
It's the latter, not the former. I agree that it's there, but it's the latter which I disagree with.
The fact is, the evidential material that you put before the Commission relating to my client, you have already agreed with me, or you didn't dispute what I've put to you, that there's not a single allegation of untoward conduct by my client. To the contrary, I now showed you a paragraph or evidence by Mr. Irving stating exactly the contrary to what you want this Commission to further investigate.
Well, you've done the absolutely classic thing, is cherry-picked one particular statement out of 2,000 pages and used that to invalidate the bulk of the rest. If it was necessary and it took another week, I'd have to do it. And then I would spend the same amount of time and resources of putting together another witness statement that led to the conclusions of all the facts that actually show the opposite of that.
I think you had your opportunity, Dr. Young. You were making all sorts of allegations and statements for many years now. And up and until now, you've prepared a statement and you didn't even make a single allegation of untoward conduct by my client. So I think you had your opportunity.
So, if you're making a statement, that's fine. But if you're giving me an opportunity, it's taken me the best part of a couple of years and many thousands of man-hours to put together my witness statement, which didn't include certainly this aspect of your client's involvement. And it was I only felt incumbent upon me to introduce this to the Commission because nobody else did, and of what I read in your client's evidence in December, there was certainly, if I'd insisted on dealing with this aspect to the same degree of detail and depth, then it would have taken me another 6 months or a year to have done it in the same level of detail.
Dr. Young, it seems to me we can summarize your testimony, and I don't even want to refer to it as evidence because it's clearly not evidence. But we can summarize your testimony in the following manner. What you actually tells this Commission is, one, you on a number of occasions went out of your way to emphasize that you have no burden of proof. Am I correct?
Yes, I think that's common cause. That's a fact.
you have further emphasized the fact that the legal principles relating to the law of evidence doesn't apply. Therefore, you're entitled to present hearsay evidence, you're entitled to present copies of documentation which we don't have an idea where it originates from, who the authors were, etc., etc. But the fact is, you did not feel yourself bound by the legal principles relating to the law of evidence. Am I correct?
No, that's also incorrect. If I may address those points as I can remember them. You say that I have just presented documents to the Commission with no idea of their origin. That's incorrect, specifically as regards these documents. It's very, very, very clear where they emanate from. They emanate from the Serious Fraud Office in the United Kingdom, who initiated this investigation. I don't think there's anything. The authors and the origin of any of these documents is entirely clear. That's the one thing. In terms of evidence, that was your other point that I can remember, was that I am, as a layperson, familiar with the best evidence rule. Well, not familiar, but I am aware of it, where if that is the best evidence in any circumstances, even if it is hearsay, then it is at least provisionally admissible. And I would say that the barrier to entry, or the bar to entry, as in legal speak, is even lower in a commission of inquiry as it might be in a normal trial. And the third thing regarding hearsay evidence, this trial does, or not this trial, sorry, these proceedings also involve the other leg of bribery and corruption. And as far as I know, and I'm not an expert in the Prevention of Combating Corruption Act, but that act specifically allows the use of hearsay evidence.
Dr. Young, for instance, the documentation that you presented now with your supplementary portion of your statement to the Commission, if I look, for instance, and it is true to more than only one of the statements, but if I look at file 10, the first transcript that you presented was a transcript of the evidence, in inverted commas, of one Mr. Macbeth. Am I correct? Page 3997 of the paginated pages it commences.
I don't see there's a Mr. Macbeth, and he's not the first one. I think he looks about, I put these in alphabetical order.
Please, nothing turns on first or second. I'm just referring to you to the first statement in the bundle. Nothing turns on it. I'm just referring to that statement.
Okay, well, I in my own witness statement, and all of these, of course, come out of my witness statement, of which you've got a copy. That's just why I said it's not the first one in my list here. There's a Mr. Macbeth, so I'm aware of that one.
Well, have you seen that it's only a draft statement, or a first draft? Please have a look at the foot of the pages.
Yes, I can see that.
What does that mean, Dr. Young?
It just means that that's the one that I have, and that's the one that I have had available to give to the Commission.
That means it is, in inverted commas, a statement that stands to be corrected. Not so. Isn't that what first draft means?
In that particular instance, maybe you're correct. As far as I know, I have copies of many other statements at least, and as you can see in there on my witness statement, they are all checked versions. I am not aware that there was another version of the Macbeth interview.
The fact is, Dr. Young, some of the so-called statements that you presented the Commission with are only first drafts. It's not even checked statements. That seems to me that that only applies to one of the 9. That's the Macbeth one. All the other ones I can see is checked. You have checked wrongly, Mr. Dr. Young. Look at Mr. Irving's statement.
Sorry, I'm looking at the file names. It also says checked. If I may just complete my evidence properly without being interrupted. I am looking at my witness statement. I don't have those evidence bundles before me, but seeing this as my evidence, I should be allowed to traverse that. There are, as I said, 8 SFO transcripts here. Julia Aldridge one is checked. Hugh Dickinson one is checked. Kevin Smith just says all. Macbeth also says all. MacDonald says corrected. McIntyre says corrected. And I know that the transcript of the Alex Roberts ones was not done in the UK. It was done in Switzerland with the Swiss prosecutors there, with the SFO people there, and that is signed by Alex Roberts himself. So that is a check. So possibly of the 9 that 7 of them are actually indeed checked.
Some of them are only drafts.
Possibly.
Well, let's not spend too much time on that. I just wanted to illustrate to you the point, Dr. Young. Then, thirdly, it seems to me, if one summarize your testimony, the third point is that after receiving certain information, that's now referring to my client, you embarked on an investigation. Would that be correct?
All I did is I then started referring to the documents that I'd been provided to me to see whether there was anything that...
Now, the information that you received, we're not in a position to identify the people in all instances who presented you with information, because in some instances it appears to me that you are not certain, and in other instances you are not willing to disclose the identity of some of these people who provided you information with. Am I correct?
Yes, but I certainly am aware of, well, in this BAE case, I'm aware of all the identities, and I think the only thing was the German ones, which is not relevant here, of who the exact author, but I was aware of at least their organisation. And if I may just say, I'm sorry to turning, but just finishing off the previous point, in fact, the only other transcript here, which I thought there were 2 that were not checked, but in fact the Sir Kevin Smith one, which is important, actually has the word checked at the beginning of the file name, not the end. So there's only the Macbeth one doesn't seem to indicate being checked in terms of the file name. Only 1 out of 9.
You're wrong, Dr. Young, but I don't want to spend time on that. In the bundles that has been presented to us, there are a number of statements from Irving, and all of them are first drafts. But let's not waste further time. The record will speak for itself. It is in front of the Commission. Let me go to my 5th point. The above information that you have received then gave rise to your suspicion, or gave rise to a theory that you developed, that my client could have influenced the deal. Am I correct?
Well, I would put it slightly stronger than that. I would say that if the contention of these BAE witnesses is correct, that they were treating Hlongwane as their agent, or at least their source of information, while he was acting as the Minister of Defence at the same time, then that would be irregular.
Then the following point, it seems to be that we can gather from your testimony, Dr. Young, is that you therefore request the Commission to further investigate this issue. Or all issues that you've dealt with in your statement, including the issue relating to my client.
Well, I think the answer is yes, but otherwise I wouldn't. If I wasn't asking the Commission to investigate further, then I don't know why I'm here.
But in this process, at least by implication, you would urge on the Commission to all the technical people who testified under oath that there was no influence. The Defence Force people, in White Line's position, more particularly the Air Force people, the decision makers who testified, all direct evidence, all people who were directly involved, not a suggestion of improper influence from my client. But what you would urge the Commission on is to please ignore those undisputed evidence.
No, I wouldn't say. Well, there are two things. I wouldn't say they should just the Commission should just ignore it. What I should say, it is disputed. The very fact that I am here has to mean that some of that evidence needs to be looked at. Just because I didn't cross-examine every single, it doesn't mean to say that it's not disputed. What I am saying, or what I'll further say, is the evidence of the South African officials, specifically DOD and Air Force and Arms Corps ones, that was from their perspective, and actually only from a very early perspective of going up to the let's say that the early 2000s maybe 97 to 2001 time frame. All of this evidence derived out of completely different jurisdictions being the United Kingdom and Switzerland, and it came in a much later time frame, I think 2007, 2008 time frame, and so that the witnesses to whom you refer just wouldn't have known this. So they wouldn't have. I don't think that they addressed this because they didn't know. If it's true that this evidence from the Serious Fraud Office is relevant, then I would just request the Commission to look at the situation in its entirety and not just from that one particular sector of viewpoint.
Can you put that question again? Because Dr. Young gave a long explanation. I couldn't quite understand whether he was answering your question or not. Maybe let's try again, put the question again, and let's see how Dr. Young responds to it.
As you please, Mr. Chairman. In this process that you urge the Commission to further investigate, by necessary implication, you urge on them to please ignore the direct, undisputed evidence of all the people involved in the process who denied any improper influence by my client, or there was no suggestion of even contact that my client had with any of them in order to influence them in the process. That should be ignored. Otherwise, where will we go with further investigation, Dr. Young?
There's only one very, very brief response I can give to that, and it's only in Afrikaans. Ja, nee.
I think we should proceed in Afrikaans, Dr. Young.
Jy mag as jy wil, maar wat ek sê is,
This wasn't an invitation for further comment, Dr. Young. It was just the joke.
Well, it takes two to make a funny joke. But if I may say, you did ask me a question there, and I think I'm just repeating myself. I did actually answer the question correctly. You're correctly. I am not asking the Commission just to ignore all the evidence. I'm asking them to view it in the balance. That's the way the law likes to work, is the lady with the scales. Has to be a balance. So I'm not asking them to put zero weight or put nothing in that side of the scale at all. I'm just saying is in the balance to also be aware of more so what the Serious Fraud Office has uncovered in a much later time frame.
Is that now a judicial balance or a young balance?
It's only my little input of taking the small amounts of weights to the relevant lady with the scale to say, I would recommend that these little weights are worth putting on that side of the scale as well.
One thing that I agree with you, Dr. Young, your contribution was indeed a very little weight.
I would disagree with that. I think it is, in terms of what has been brought so far, I think it is gigantic.
Further, Dr. Young, the Commission should also disregard, for instance, the view clearly expressed by somebody like Irving that there was nothing untoward and that there was definitely no attempt to obtain financial benefit from somebody like Mr. Shilongwane.
You see, you're just cherry picking, and it's just completely inappropriate. You know, I have. There was more aspects to just. Well, in fact, let's just drill down to the one aspect. The most important aspect is that payments came in this earlier time frame, this 99 to 2001 time frame. And what Mr. Irving does in his multi-page transcript of his interview, he might say that, and I'm not asking for that to be completely ignored. I'm not hiding. I didn't typex that out. I didn't redact that out, or hide the page, or fiddle with the evidence. But what is very important from Mr. Irving's evidence is the aspect of covert commissions, and he specifically refers to a very, very important player here, being Sir Alex Roberts, from whence your client, Mr. Shilongwane, received a fraction under £5 million of payments from BAE through Mr. Roberts' company, or Sir Alex Roberts' company, Aster. And where now Irving is on the record, and that's why his transcript is relevant, it's important, is that he refers to the covert commissions, and he tried to reduce the covert commissions where Alex Roberts refused. And it's the inference, actually, from the questions of the SFO, and it might be that, I can't remember now whether Niall Irving agrees or not, there's a very strong reason for that, or probable reason, is that actually Mr. Roberts was actually acting as another agent, as agent for an agent. Okay, so that's the one thing. The other,
Which question are you answering, Dr. Young?
I'm answering the question regarding the relevance of the one tiny bit of information contained in Niall Irving's transcript, and saying why you can't just take one tiny little thing out of Niall Irving's evidence and say, well, that becomes de facto. That is the, well, let's say the smoking gun in that context. There's the rest of his evidence that needs to be put on the scales as well.
Dr. Young, you should further, or the Commission should further on your attempt, ignore the undisputed evidence of Mr. Shingwane himself.
Well, I'm disputing his evidence.
Why didn't you come and cross-examine him?
It certainly would have been impossible for me to do so on the 11th of December, and just like all the other witnesses that I only became aware of his evidence and his witness statement after he actually stepped off the stand.
Well, the objective position is, Dr. Young, is evidence disputing any suggestion of untoward conduct was completely undisputed. Not only did you chose not to dispute that, but not any of the other critics to the arms procurement process, in fact, turned up in order to cross-examine him and give him then the fair opportunity to respond to allegations.
No, I think, well, at least here, I can't say you're fundamentally wrong or I am, but certainly something that I have traversed with other people regarding advice is I am unaware of any legal situation, whether it's a trial or a quasi-legal, where a witness, a person who has been on a witness list for those proceedings, actually right from the beginning, where a witness is obligated of cross-examining another witness. I am a witness, and I can adduce my own evidence in my own evidence, in my own evidence in chief, and of course cross-examined. There's no obligation for me to cross-examine another witness.
Now I don't understand. I understand you involved yourself in quite a lengthy cross-examination yesterday. I was fortunately not here, but I understand you did, in fact, cross-examine yesterday to some extent.
Well, there's completely different circumstances. I was completely different circumstances. Your client testified nothing whatsoever, nothing, zero regarding me. I think that has to be common cause. Secondly, of course, I wasn't aware that what your client was going to testify about, and of course I wasn't in the vicinity. Yesterday's circumstances were completely different. First of all, it involves an entity which I have referred to in my own evidence.
But you've referred to my client in your own evidence as well.
No, but you're not listening to me. I would say is that your client never referred to me, whereas this a witness yesterday from Charlie's did refer to me. Sorry, it has to be. You don't need to be a legal brain here to know the difference. This is completely different circumstances. And I hadn't finished what I was saying, is as I was confronted in a situation regarding your client, is he stepped off the stand and was released before I knew what he was going to testify about. Yesterday, it was a big surprise to me. I only found out that the witness from Charlie's was going to be giving evidence yesterday morning around about this time, which is close to tea time. In fact, I had to interrupt giving my own evidence in allowing her politely, as the commission allowed her to do, to finish. But I was at least provided with a witness statement at the beginning of lunchtime, so I had an hour to peruse it, and I was put in a position to ask some questions. So the circumstances are completely different. If you want me to put it higher than that, I will try and do so.
I will not give you the opportunity, Dr. Young. I want to put to you that my client emphatically denies that he was at any stage involved or has any knowledge of anybody within and or outside the government of South Africa who improperly influenced the award or conclusion of any of the contracts awarded in the SDPP procurement process.
Unfortunately, the evidence shows that your client is prepared to give untruthful evidence to this commission. So, unfortunately, he might state that. I would contend that by dint of logic, if the other evidence is true, then that evidence, what you've just stated now, has to be regarded in at least putting it politely, in an inquisitorial light.
Mr. Chairman, as far as I'm concerned, I'm finished. I see I transgressed over in the tea time period. Can we take the short adjournment that I just get a final instruction from my attorney? But as far as I'm concerned, I'm finished with the cross-examination.
Okay, maybe let's take a 15 minutes tea adjournment. Thank you.